Thank you, Mr. Chair. Dear Professor, thank you very much for the invitation and taking the possibility to take part of this honorable conference. With regard to the representation of my university, I'm here to take the opportunity to say some words about the amendments and the development of the Slovak Criminal Code and the Slovak Procedural Criminal Code, how the development took part since 2005. With regard to the substantial part of the criminal law, meaning criminal code, actually the criminal code has been adopted in 2005, so actually it is 17 years old currently. From the number of adopted amendments, we can say it's a relatively level act. Currently, it has 43 amendments. The tendencies with regard to the criminal code are actually punitive-oriented, and currently the mindset of the whole and the idea of the whole criminal code is trying to change and put the direction towards the restorative justice, what are actually also the new tendencies in the punishing and execution theory of the criminal code. What we struggle, or what I found one of the disruptive elements of the development of the criminal code, and I will elaborate it deeper with regard to the criminal procedural code, is actually we do not conduct any examination of the effectiveness of adopted amendments or novels. What means we do not consider it ex ante or ex post. If the adopted legislation is really necessary, if the adopted amendments are really ultima ratio, without considering prior possible activities such as judiciary decisioning and so on. What leads us to the conclusion with regard to the substantial part is actually that the amendments of the criminal code are mainly, or changes of the criminal code are mainly driven by the case law with strong casuistic principle that particular amendment, particular novel of the criminal code trying to resolve certain application problem. What I consider from my perspective as a bad way, put it this way. And secondly, unfortunately, in these last years, it's very strong driven by the public opinion and the political will of changes, the criminal code. Here, very briefly, these are the main changes of the criminal code. I will not go one by one. Just to illustrate that none of these amendments were adopted with previous or ex post serious research of effectiveness of the prior legal status, nor the effectiveness of the amendment as such, as I concluded before a minute. You can see, or from very brief overview, you can see that majority of the changes are related to the penal policy, to the punitive effects of the criminal code, and to the non-conditional sentences, execution of non-conditional sentences. Slightly different change will be with regard to criminal procedural code, Slovak criminal procedural code. Also, it is a almost full age child, so also 70 years old. even more amendments. Also, it's very level act. Currently, the Criminal Procedural Code included 53 amendments. What is the general overview? Again, I will drive your attention to the consideration of effectiveness of these amendments. How the Criminal Procedural Code dealt with that? The answer will be quite simple in another way. What are the basic principles of the criminal procedural policy and what are the basic overviews? So, despite the fact that number of inmates serving non-conditional sentences increases, but the overall known and reported criminality decreases. How come? If we ask ourselves how the amendments are effective or should be effective. The second overall conclusion is that the pretrial files per investigators are increasing, again, despite the overall reported decrease number of criminality. Usually, the trial standards that are adopted by the Supreme Court are also applied, unfortunately, literally, to the pretrial stage. What means that pretrial stage in the Slovak Republic under current legal status is very formal. The procedural actions are repetitive, and the whole pretrial stage is overloaded by administration. Also, with regard to criminal procedural codes, you can spot the new tendencies incorporated in the criminal procedural code, and those are mainly related to the new forms and new tools of the restorative justice. However, what I have said with regard to criminal code, that we are not able to examine the effectiveness of the amendments and the effectiveness of the whole criminal code within this text. Our university tried to conduct this research with regard to the criminal procedural code, and mainly we have focused on the pretrial stage. So we have analyzed one particular aspect or determinant of the effectiveness, and it is the speed of the pretrial stage. Or was it the speed of the pretrial stage? What we have concluded once we were comparing particular legislative amendments of the Criminal Procedural Code in comparison to the speed of the pretrial stage is actually the result. You can see that none of the amendments has major impact on the speed of the pretrial stage, and only one determinant has occurred as a decisive in the speed of the pretrial stage if we check it from the perspective of the effectiveness, and it's the number of investigators and number of the prosecutors. So more policemen we have, speed of pretrial stage we can perform. What brings me towards the basic questions I want to actually conclude that none of the amendments adopted have no major impact on the speed of the pretrial stage from the perspective of the effectiveness. So quite unpleasant results from our research. Here you can see actually only one legal tool that has major impact on the whole criminal proceeding, not the pretrial stage, but the whole criminal proceeding, including trial, and this is actually the plea bargaining. This is the plea bargaining that in the application practice has strong impact, decisive impact on the overall speed of the criminal proceeding. Unfortunately, the impact can be mentioned and can be spotted only with regard to the trial phase of the criminal proceeding, not the pre-trial phase, because the pre-trial stage an investigation needs to be conducted also in the plea bargaining cases. So what should be the conclusions for the academic area, or also for the legislators in the Slovak Republic with regard to the criminal code and the criminal procedural code? And what is our recommendation? It is actually the it is the examination of the effectiveness of the amendments. Start to formulate and elaborate the determinants of the effectiveness of the criminal law, criminal procedural law, and do the best and turn towards the legislators and the decision makers to incorporate the examination of the effectiveness of the amendments also in the formal legal drafting process. So basically, if it is really necessary to amend particular provision, and if so, submit it or support it by the hard data, if this is possible, and answer also the question whether the provisioned amendment or draft gives the right answer to the problem that has been identified by the examination of the effectiveness of the particular provision. Very briefly from our side, I hope you haven't been bothered by our presentation. If you have any questions, I would be more than happy to answer it later. Thank you very much.